Good afternoon. It is just after 12 here in New York City. I'm Gabe Oberfield, your host for this week's Bonds Business in 22 webinar. It is a beautiful day here in the city where it is starting to feel all the more like summer. And we're excited to bring updates to you as we do every week at noon on Tuesday. There's a terrific lineup ahead, but let me walk through a few housekeeping items to make sure that everyone is comfortable with the ground rules for today's discussion. First, if you have questions that you wish to raise, you can enter them into the Zoom chat function. We'll do our best to answer those questions as a group over the course of the webinar in real time. If there is something, though, that we can't get back to you on right away, we will follow up with you. Everything today that we're presenting is informational. It's not intended to be in the vein of formal legal guidance, so please approach it in that spirit. And as always, this webinar represents a sampling of the kinds of issues that we see and encounter here as a firm at Bond. And we encourage you to contact the attorney with which you work most closely if what we present here spurs any question or concern that you'd like to dig in on a little bit more deeply. And with that, let me introduce today's program. Again, I am your host, and I will spend the first 10 minutes or so walking you through not only these initial remarks, but as well, we'll look at where we are on COVID. We'll also touch on where we are with the New York State Legislative Session that just wrapped, and I'll mention the New York City budget. We'll then move to Dustin Drosino, who's going to talk about cannabis regulations, a big moment here in New York State. Travis Tallarico will move on to the Cures Act and information blocking provisions thereafter. Paul Bueller is going to look at unemployment insurance for us. Kat Grazios is going to touch on telehealth, and then I will take your questions and wrap us up by 12:45 Eastern. So with that, Brian, if you go to the next slide, please, and one after that as well. So today's COVID picture nationally is one where we're leveling off. We saw, of course, last time I was your host about 2 weeks ago, that we were seeing a pretty significant rise in cases. Right now, we're looking at a relative 2-week span where we've dropped 1% nationally in cases, which is a sign that what we were seeing in terms of the late spring surge is starting to calm down a bit if you look across the country. But if you were to go to the next slide, please, Brian, I'll show you where we see some hot spots. If you look at the May 31st picture on the left-hand side of the screen, what I'm most interested in focusing you on is that the right-hand side of the screen looks markedly different, particularly in California and in the Four Corners states. Definitely upticks there in the western component of our country. So although we're seeing a net 1% drop, it is not equally distributed. Next slide, please. In New York, where I'm speaking with you from, we're seeing a much better picture, thankfully. There is a 37% drop in the caseload over a 2-week period, which is definitely a significant difference. There are no new mandates, federal, state, or local, to bring to your attention. Nothing new on indoor masking. And in fact, for the first time in about 2 years, kids in New York City daycare and other programs for toddlers no longer have a mask requirement in place. That was lifted as of yesterday. So there is a lot of change in terms of the level of stringency we're seeing here in New York, even as nationally, we're still seeing a fair amount of COVID out there. Next slide, please. So if you look at the 2-week differentials, which I try to make sure that you have a chance to look at every time I'm hosting here, you'll notice that there is that 37% drop that I mentioned. And as well, in every meaningful county or geography reference, there is a drop. So all of this is looking good across the state. Next slide, please. With the time I have remaining, I'm going to walk you through that New York State Legislative Session I mentioned. It wrapped up earlier this month, and there are a few items that I'll highlight. There's more that we can discuss, but I'll give you just a glimpse into it. Next slide, please. So on reproductive rights, I mentioned during our last session that I hosted that there were a number of bills that the governor was going to be considering for signature, and the legislature was very active in the context of what we expect will be the Supreme Court's decision on Dobbs, which may affect reproductive rights at a national level. And so the governor actually, in a signing ceremony, just signed all those bills that you see on the bottom left of the screen. That is a large number of ways in which the governor is trying to, along with the legislature, of course, position New York State ahead of that kind of change at the federal level I was alluding to. The broader constitutional amendment did not make it through. And for now, that is something to come back to in a future instance. Let me go to the next slide, please. And I'll also touch here on examples of legislation. Again, there's a lot more we can talk about, but with guns and assault rifles specifically, as a country, we're living with the resonance of these terrible incidents that we had here in New York State and Buffalo, and then in Uvalde, Texas. New York State passed a wide array of pieces of legislation that the governor also has signed into law, outlined here. Just over the weekend, actually, at the federal level, there was some movement in this regard as well. So we're seeing a lot of action nationally around assault rifles and other types of activity that is ultimately a response to these tragedies that we've endured as a society. Next slide, please. New York City, where I'm speaking with you from, also got its budget done early. The next fiscal year starts on July 1st. And while this isn't per se legislation in the same way that I was describing New York State, it's a big deal that New York City has a budget that is agreed upon. And it's also one that is much more robust financially than anyone would have predicted even a short time ago. The proposal that Mayor Adams introduced was in the vein of $98.5 billion. The final agreement was about 101 billion, excuse me. And that really derives, that difference, I should say, from far better than projected revenues. There's also now a sizable investment by way of this agreed upon budget in the city's rainy day fund, actually more than had been proposed by the mayor in that initial budget offering. And a big thing that New York City human services agencies have been raising their voices for many years running was a cost of living increase. That is at a pretty significant level baked into this budget too. So let's go to the next slide, please. And with that, let me take a moment to introduce Dustin Drosino. Dustin Drosino is with us from Syracuse, and he focuses on general corporate and transactional matters, including M&A and formation and dissolution. And one of the other things I'll mention about Dustin is he attended the Syracuse College of Law, where he was executive editor of the Law Review. He also, before joining Bond during his summers, worked in the city of Syracuse and as a law clerk. And he's going to tell us about cannabis. There is a lot of movement across the country, of course, around essentially new regulatory and statutory structures. And for the first time here in New York, we have regulations for adult cannabis use. And so, Dustin, please walk us through. We look forward to learning from you.
All right. Thank you, Gabe. Hello, everyone. It's also a sunny afternoon in Syracuse, New York. And like Gabe said, it's a very exciting time in the state of New York since the first regulations for New York's adult use cannabis industry were just recently approved. The regulations establish standards for packaging, labeling, advertising, and marketing of adult use cannabis and cannabis products across the state of New York. While these regulations don't have immediate implications for potential license applications in terms of the information that they'll need to put in those applications to get licensed in order to make those cannabis sales later in this year or early 2023. They do have wide-ranging implications for New York State's emerging cannabis market, as these regulations are going to apply to all potential vendors in the state. The purpose of these regulations was to promote consumer safety, and especially for children. The Office of Cannabis Management approved these regulations, which were brought about by the Cannabis Control Board on June 1st, and they'll now undergo a 60-day public comment period and become effective on July 31st. Next slide, please. All right, the regulations delineate specific requirements when it comes to the packaging of cannabis and cannabis products in the state of New York. Specifically, all packaging is required to be child and tamper resistant. And the standards for child and tamper resistant packaging in the state of New York are delineated in the Poison Prevention Packaging Act. And future vendors are going to have to make sure their products undergo special testing to determine the effectiveness with which children and senior citizens are able to open cannabis and cannabis products and meet certain enumerated standards. When marketing these products, vendors are not going to be allowed to use any marketing strategies which appeal to children under the age of 21, including any cartoons or cartoon-like font on packaging, using bright or neon colors, using the term candy or any other similar words, using images of people who are reasonably appear to be under the age of 21, using any sound or scent emitting features, or using any characters or toys or public figures that are commonly used to market to persons under the age of 21. The Office of Cannabis Management also specified limitations on vendors using their brand logos and names in their packaging. And while vendors are able to use their brand logos and designs on product packaging, they won't be able to use any more than one brand logo or name. And any pictures or graphics used on packaging for cannabis-related products will have to follow future specific regulations that the Office of Cannabis Management will come out with. Also, as part of the new regulations and the application process, vendors are going to have to submit an environmental sustainability program for all of their product packaging. Businesses are going to be prohibited from using single-use plastics in all of their product packaging unless it uses a minimum of 25% post-consumer recycled content. Next slide, please. The regulations also included many standards when it comes to labeling cannabis and cannabis-related products, one of which is to include a state licensed logo on all products. And this label has been developed by the Office of Cannabis Management and will be delivered to all licensees upon granting of retail license later in 2022. The logo is a universal symbol that means the cannabis product has been tested and is safe for public consumption. And it looks like a yellow flower in a triangle with a 21 plus symbol in a red circle atop of the New York State logo. All products are going to be required to have an informational label, and all edible products are going to need a nutritional label. These labels are required to include such things like THC content, serving size, a list of active and inactive ingredients, an expiration and use by date, storage conditions, contact information for the manufacturer and distributor, usage instructions, and a scannable code with a link to a certificate of analysis that all vendors are going to have to keep on file. That means that the products that they are selling to the public are safe for consumption. There's also a wide list of product warnings that vendors are going to have to include on their packaging. A lot of these warnings are aimed at children under the age of 21, pets, and women who are pregnant or nursing. You will also have to specifically warn about the smoking hazards and potential delayed effects of any edible cannabis products. And the warnings are going to have to be displayed in a specific font, bold typeface, and no less than font size of 6 in a bright yellow box on the principal packaging of cannabis products. Any violations of these regulations, including claiming links to health-related benefits, using the words craft or organic, promoting price discounts or overconsumption, or anything that would market them attractive to children under the age of 21 could result in suspension, cancellation, or revocation of any cannabis licenses. Further, the regulations place a duty on all licensees to check any products that they receive from manufacturers or distributors and make sure that they comply with the regulations. And if the products don't comply with any of the packaging or labeling regulations, vendors are going to be required to notify the Office of Cannabis Management and either return or correct the product before marketing it for sale. Next slide, please. The regulations also included a part about marketing and advertising of cannabis and cannabis-related products. If businesses want to market and advertise their products, the primary purpose must be to inform consumers and not promote the THC content of their products. All marketing and advertising materials must include several warning statements and also the name and license number of the vendor. Any websites that vendors use to market their products must have a mechanism to prevent children under the age of 21 from being able to access the website. And if vendors wish to use any outdoor signage to market their products, the regulations also list specific limitations on the size, location, and content of that outdoor signage. There will be prohibitions on various activities that vendors will be able to do, including using billboards, brochures or handbills to pass around outside or at stadiums, and the use of any mascots to promote cannabis products. You also are not allowed to promote the THC content of any of your cannabis products or use any colloquial references. If vendors want to sponsor any events or sporting contests, they have to have reasonable evidence that at least 90% of your audience is under the age of 21. And any apparel that cannabis businesses wish to manufacture for their customers must be limited to adult sizes, and sales can only be made on licensed premises. Next slide, please. And if anyone has any questions, I see that there are some questions in the chat for me. I'll answer them as the webinar goes along. And if anyone has any questions after this, you can feel free to reach out to me via email or phone. Thank you.
Dustin, that was really helpful. Thank you. As you mentioned at the top of your presentation, it's an exciting time in New York, a whole new set of regulations around an industry that is building out for the first time really in our state's history. So with that, we'll shift gears and we're going to hear from Travis Tellerico. He's based in our Rochester office. Travis has presented before this Business in 22 program before, and he'll be familiar to you. He concentrates his practice in labor and employment law and corporate litigation. It's also worth noting that he also attended the Syracuse College of Law and was a member of the Law Review while there. So Travis, the floor is yours, and please walk us through what's going on in the CARES Act.
Thank you very much, Gabe, and hello, everyone. Hope everyone is doing well and enjoying the long overdue weather that we've finally gotten here. So today I'm going to be talking about something that's a little bit outside some of the things that I've spoken to some of you about on the webinar before, and that is a amendment to the Cures Act, which went into effect over a year ago now, but is still something that I think is worth, it is quite topical both for healthcare providers to understand their obligations under the amendment, and for individuals to be aware of some rights that are granted to under that amendment. So, as I mentioned, the Cures Act, the amendment to the Cures Act went into effect on April 5th, 2021. Now, the general purpose of it is essentially to increase transparency and allow patients to access their electronic health information in effect when and where they want it. So the general purpose of this is for providers to start implementing such procedures such as web portals or apps where patients can have their medical records available for view, test results, et cetera, when and where they want them. Next slide, please. So exactly what is information blocking? So according to the Cures Act, it is defined as a practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. Next slide. Now, who is subject to these provisions? So in effect, who has obligations under this amendment to the Cures Act? So there are three main categories: healthcare providers, developers of certified IT, and health information networks and exchanges. For the purpose of this webinar here, we're going to be focusing our conversation around healthcare providers, as assuming that's going to be the most people on this call that are affected by this. So as we can see, I'm not going to bore you with reading this full extensive list of the things that are the various types of entities that are defined as a healthcare provider. But as we can see on this slide here, that definition is very broad. So including entities such as large as major hospitals, also includes clinics, blood centers, surgical centers, pharmacies, and even basic smaller physician practices as well. So in effect, any and all healthcare providers are subject to this act. And next slide, please. So what is required of providers that would not constitute information blocking under the new provision of the Cures Act here? Essentially, the Cures Act requires healthcare providers to allow access to patient electronic health information in real time without having to go through essentially requesting records or test results. So practically, as I've kind of alluded to, this could mean that a patient would be able to access their electronic health information, such as test results or their chart or their medical charts, essentially almost in real time, that those results are available to the ordering clinician. Now, the amendment to the Act does not explicitly specify what types of mediums a provider must use. However, there is language in the final rule that was passed that doesn't seem to encourage either an electronic web portal or an app where a patient could sign in on their phone and be able to access that way. And next slide, please. Now, in terms of, so it's been over a year since the Cures Act has been out, and I know I've talked to a few clients who only recently have learned of it. And the way the rule is written is somewhat interesting. So it doesn't necessarily require a provider to take proactive measures to provide electronic health information to their patients who have not requested it. However, which seems to be a bit of practically conflicting language, a provider is supposed to have some sort of policies, procedures, and systems in place to be able to provide that information in a timely manner. Now, this is what can constitute information blocking under the Act, is a delay in the release or availability of electronic health information in response to a legal request under the Act. And if the delay were to constitute interference, then that might implicate the information blocking provision, but there are several exceptions, which will be on the next slide. So we have the 8 exceptions here: preventing harm, privacy, security, and feasibility, health IT, content, manner, fees, exceptions, and licensing. For the sake of the 10 minutes I have here, and I apologize if I'm going through this quite quickly. I know this is a very, very high level overview here, just trying to get through the content that I want to touch on. For any specific questions, would be happy to address exactly what these exceptions are. I guess briefly to touch on a couple of these. So the infeasibility is one that I think may be relevant for providers, which essentially kind of gives some wiggle room for providers to not have to, the legislation here recognizes that it's going to take some providers significant time, effort, and expense to be able to provide what the act requires. And so the infeasibility exception kind of touches on that a little bit, recognizing that it will take time for providers to put some of these things into place, might be having to work with their EHI vendors to implement some new systems. However, I will say, and one thing I've been speaking to some clients that have had some questions on this, I definitely don't think this is a stick your head in the sand kind of thing. And even though understanding some of the roadblocks that are maybe in place for various entities in terms of cost, expense, and time to implement, I don't necessarily think this is something that could be ignored forever. Next slide, please. So the question is what is EHI? And again, for the purpose of keeping this presentation relatively short and sweet, I didn't go through specifically all of the data elements or what is defined of EHI. If anyone has specific questions about those, I would be happy to provide those separately after this presentation here. So presently, EHI, the data elements are in the United States Core Data for Interoperability Standard. Bit of a mouthful with that. Which generally speaking, most providers that have EHI systems in place already are providing or have access to the type of material that's required under the Act. Now, however, in a few short months, actually, the EHI definition will be changing and is expanding to include the full HIPAA electronic designated data set. And please note that the HIPAA still does apply here, which is can create its own complications with working with third-party vendors. But again, this is getting about outside the scope of the presentation. Next slide. And finally, and this is, I'm sure, a question for any healthcare providers that are on the call. Are there any penalties for non-compliance? As the last time that I looked, as of a few weeks ago, I have not seen any sort of defined penalties for providers for non-compliance, other than just kind of a vague reference to general disincentives. So with this being said, assuming that there will be some more specified penalties for non-compliance coming down the pike, but that is yet to be seen. And again, acknowledging that this was overall a significant amount of information to cover in 10 minutes, I had to try to be somewhat mindful about crafting this for time. Again, please, any specific questions that arise, reach out. I'll be happy to address those.
Travis, thank you for getting through what was a really significant presentation and making it all the clearer to our audience that you're available in follow-up. And so anyone who wants to dig more deeply on these issues with Travis, please do reach out. Let me switch now to Paul. Paul Bueller is with our Albany office, and he's also an attorney who specializes in labor and employment matters. And he is a graduate of the Albany Law School and Cornell, and is going to be talking to us about the changing landscape of unemployment insurance with a few quick updates. So Paul, the floor is yours. Thank you for coming back to the webinar. It's been a bit since you have joined us, and we're glad you're here with us again.
Yeah, thanks so much, everybody, for having me. So I just want to cover just a couple of quick kind of trends that we're seeing in the unemployment insurance space. Certainly, this is something that I've spoken about on this webinar a number of times previously, but not for a little while. So just as a quick reminder, early days of the pandemic, we had the CARES Act, which basically, expanded unemployment insurance categories, provided some relief for self-insured nonprofits. Now, the most recent update is for you self-insured nonprofits. If you recall, a little over a year ago, the New York State Department of Labor basically came out and said, we're going to cancel unemployment insurance benefit charges for all employers through the declared state of emergency. The state of emergency ended about a year ago, but the Department of Labor kind of quietly continued that relief for you self-insured nonprofits. So one of the questions that we've been seeing a lot of is, I'm starting to get bills again for unemployment insurance. How do I know if they're right? How do I know if they're accurate? So again, for you self-insured nonprofits, really the important thing to remember now is that as of January 1st, 2022, that cancellation of benefits is over. So new charges that are incurred as of January 1st, 2022, that's what you've got to be paying. And so as you receive these new bills, you probably got your first quarter bill relatively recently. You'll be getting your second quarter bill pretty recently. I would just recommend that you reconcile those, make sure that they are accurate and that it's only charging you for charges, unemployment insurance benefit charges that were incurred as of January 1st. Some of you who were already paying previously, because the CARES Act only initially included a 50% relief, and then New York State said, we'll give you 100%. Some of you may even have a balance of overpayment that should be applied. So again, all the more important that you review those charges, make sure that if you have a balance, that overpayment balance is being applied to your charges moving forward. And again, you're only paying for charges incurred in 2022. The second kind of important trend that I wanted to talk about is, we're seeing a growing number of unemployment insurance hearings, and the overwhelming majority of them right now kind of stem from employees who either quit or were fired over receiving the COVID-19 vaccination. So at the outset, the Department of Labor basically came out and said, if an employee refuses the vaccine and doesn't have a properly approved accommodation request, whether that's a medical accommodation or a religious accommodation, that individual is going to be disqualified from receiving unemployment benefits. Now, in the healthcare space, obviously all of you guys are aware, New York State mandate that healthcare workers in personnel positions, effectively individuals who are interacting with coworkers and patients, they have to receive the vaccine. And the Department of Labor has sort of adopted the reasoning of that We the Patriots versus Hochul case, basically saying that a healthcare employer is obligated to engage in the interactive process for a religious accommodation, but can't provide an outright exemption. And so if an individual has one of those personnel position, they're interacting with patients, they're interacting with coworkers, et cetera, that's a situation where the Department of Labor has come down very hard and said, we're going to deny unemployment benefits in that situation where an individual, again, either quits or is fired over their refusal to receive the vaccination. One of the things that I think are starting to see, but haven't seen quite as much is, other employers who are now mandating the vaccine. So I wanted to give you guys also a little bit, a couple of tips, ways that you can help to kind of justify, the Department of Labor potentially denying unemployment insurance, charges for your individuals if you're a non-healthcare employer, but you did mandate the vaccine. And so for you guys, one of the key things is kind of justifying why you have a vaccination mandate in the first place. The Department of Labor has said that if you have a legitimate basis for your vaccination mandate, then sort of the same framework is going to apply as applies for healthcare workers. Basically, if someone, doesn't get a properly approved accommodation request, again, whether it's medical or religious, and they refuse the vaccination, as long as you have some legitimate reason for requiring that vaccination mandate, those individuals, again, are going to be denied unemployment benefits. So, for you non-healthcare employers, a lot of these justifications are going to include things like close in-person interaction with coworkers, with customers, with vendors, as opposed to an employer where someone can work remotely from home and it's not going to impact their ability to do their job. So just to kind of summarize here, a couple of practical tips for everybody. Again, review your statements, make sure that they're all accurate. This is especially important for your self-insured nonprofits. As you are contesting unemployment benefit charges, again, whether you're a healthcare or a non-healthcare employer, you always want to provide, especially in the vaccination context, provide your policy, provide any correspondence you have notifying individuals of, both your vaccination mandate and the reason behind it. If you're a non-healthcare employer, you are going to definitely want to include some justification for why you have a vaccination mandate. And, in a lot of these situations, because your justification is going to be that they are interacting with coworkers, interacting with customers, patients, vendors, whatever it happens to be, you may need to include some analysis or some explanation as to why that individual had to be fired or ultimately why they quit, as opposed to being transferred to another position. Basically just a brief summary of that kind of interactive process that we all go through when someone requests some sort of accommodation. So basically, those are the kind of trends that we're seeing in the unemployment insurance sphere, again, specifically around the COVID-19 vaccination. If you have any questions, feel free to drop them in the chat or to shoot me an email or anything like that.
Paul, that was really helpful. Thank you for catching us up on what you're seeing in your practice. And I'm confident that you'll be hearing from participants here if they do have questions. And let me now then turn to our final speaker, who is Kat Grazios. Kat and I have the pleasure of working pretty closely together. She practices in health law and as well with a focus on long-term care. Kat is based out of our Albany office, and like Paul, also attended Albany Law. And Kat's here to tell us about some changing trends in the telehealth space. It is a topic that is far too broad for us to address in the few minutes we have remaining, but Kat will be giving us some top line information that we're hopeful we can then build on in webinars that come later in the calendar following Kat's presentation. So Kat, the floor is yours, and thank you so much for taking the time.
Thanks, Gabe. As Gabe mentioned, I'm Kat Grazios. I'm an associate in our healthcare and also our higher education practice groups here at Bond. So if you have any questions about what I'm about to go over as they pertain to higher education, please feel free to reach out. Next slide, please. First, I'm going to cover some of the New York specific telehealth executive orders that we've seen. Most recently, and as was passed at the end of May, Executive Order 4.9 extended Executive Order 4 up until June 29th, 2022. What Executive Order 4 did was allow for different professions that are licensed outside of New York State to practice in New York State without obtaining that New York license. That's pretty significant because New York is not a part of any interstate medical compacts or interstate practicing profession compacts. Those are compacts with about 30 plus different states that say, if you're licensed in one of our states, we're going to recognize your licensure among the states in the compact. That's not the case with New York. But Executive Order 4 temporarily suspended and modified education law and regulations for physicians to allow physicians that are licensed and in good standing in any state in the United States to practice medicine in New York. We similarly saw this in Executive Order 4.9 or Executive Order 4 as it applies to registered nurses, licensed practical nurses, nurse practitioners, physician's assistants, and respiratory therapists and technicians licensed for respiratory therapy. Again, these individuals that are licensed and in good standing in any state in the United States are now able to practice in New York under this executive order, which typically in the past they would not have been able to. And interestingly enough, we've seen more permanent trends federally with telebehavioral health. This also extended so that way individuals who are licensed master social workers, licensed clinical social workers, or substantially similar titles, so your licensed mental health counselors, psych NPs, these individuals also who are licensed and in good standing in a state in the United States can practice in New York. So this is significant for those of you who may have employees who are coming into New York from out of state, or if you're a higher education institution or other educational institution that has students coming from out of state into New York, they might have their own telehealth provider. Under this executive order, it would be okay for them to offer those services with the students seated in New York, so long as they are licensed and in good standing in another state in the US. Next slide, please. So as mentioned before, that's a more temporary extension. We haven't really seen whether it's going to be permanently adopted, but once it is, we'll be the first to know and let you know about that. On the more permanent front, we've seen some changes with telebehavioral health, and on April 25th, amendments to 14 NYCRR 596, that's an Office of Mental Health regulation, that went into place. It expires June 23rd. It's already been extended several times. It's an emergency regulation adoption, meaning it will depend if stakeholders leave commentary indicating that they want this to remain a permanent regulation. So right now, this is allowing the change in originating site. Originating site is the term in telehealth used to describe where the patient is seated. So this updates the definition of originating site to now include residences, other identified locations, and significantly here, temporary locations out of the state. So now the patient can be seated outside of the state. So you may be asking, how do I get approval to do this? Well, you have to get written approval first from the Office of Mental Health if you're a telehealth provider to offer these out-of-state services. How do you get that written approval? You submit sufficient written demonstration that your telehealth service will be used for the assessment and treatment service, and it's a license designated authorized by the Office of Mental Health Service. This submission also has to include a statement that you have confidentiality protections in place, a statement that you have procedures to assess whether the patient can actually receive telehealth services. You have to have a policy on informed consent, which is a little bit different in the telehealth world than it may be in the typical face-to-face therapy world. You have to have procedures for handling an emergency should one arise with your patient. They might be seated in another state somewhere far away and have a mental health emergency. You have to have a procedure in place how to handle that. And then finally, you have to have contingency procedures in place for in case your services are interrupted, in case there's a technical difficulty that may happen. Next slide, please. And finally, I want to touch quickly on some federal telehealth guidance. Just yesterday, the Office of Civil Rights, which is a function of the U.S. Department of Health and Human Services, issued updated guidance on HIPAA and how HIPAA plays into audio-only telehealth. Audio-only telehealth is as it sounds. It's telehealth without any video communication. It's much more accessible to those of lower income or those who may have different disabilities, inhibiting their ability to communicate via Zoom or an actually HIPAA designated function. So this guidance that just came out yesterday replaces the previous guidance, which essentially was just OCR saying, we're not going to penalize those who make a good faith effort to comply with HIPAA. Not the most helpful guidance. Now we have other guidance in place saying, actually, this audio only telehealth does comply with HIPAA. So following HIPAA with your audio telehealth means you will be in compliance with OCR and not be penalized. And also, I just want to point out that it's important to remember with telehealth, there's really two main issues that come up: HIPAA compliance and whether it's going to be covered by Medicaid, Medicare, or private insurance. So just keep in mind that this guidance is just saying that now audio telehealth is compliant with HIPAA. It's not OCR making a statement about whether it's covered under Medicare or other federal government assistance programs. And that's all from me.
Kat, that was terrific. Thank you for that update. We look forward to having you back on the webinar. And we're nearing the close. I wanted, though, before we wrap up, to make sure that all of you know Adam will be your host next week on the 21st. I'll be back on the 28th. We've been seeking to answer your questions all along that have come through on the chat, and we've gotten to, as far as I can tell, all of them. Anything that any of you has in follow-up that you want to bring forward, send it to me. I can make sure to get it to the right person in the firm. And really just looking forward to continuing to share what we know here and being with you on a weekly basis. So until then, you have our contact information, and feel free to reach out to any of us. Be safe and well out there, and enjoy as we cross into summer. Have a good day.